record so I don't forget to do that. Okay, what questions do you have? X.
Attenuation doctrine one more time?
Let me put back up what I had on the screen before, just so that we are all looking at the same thing. And you can tell me, rather than saying, can I go over it again, you can tell me what about it specifically is unclear to you.
So, it's a little confusing because we went through all the, like the harmless error, discovery and all that. I really don't.
Okay, so let's say you have some evidence that the state has, that either the police have gotten through the investigation or the prosecutors, their investigators have gotten, which was obtained illegally. That is to say, when we say obtained illegally, you understand that what that means is there's some sort of incorrect procedural matter. There's some procedural matter that was handled incorrectly by the state. They didn't get a search warrant, okay, or the search warrant was defective, or whatever the specifics are. That's what I mean when I say, and most people when they say the evidence was obtained illegally, okay. So the question is, can that evidence be introduced at trial in an effort on the part of the state to obtain a conviction? And as we've said now for several class meetings, for many, many decades, the answer to that question was an unequivocal no. Okay, no, of course it can't be admitted. If the police administer an effective search warrant, if didn't get a search warrant, there was something wrong with the search warrant, the evidence just is not going to be admitted. Well, the courts began to say by the 1980s that, well, not so fast. It doesn't automatically have to be excluded at trial. It doesn't automatically have to be suppressed at trial. It may be introduced for a variety. There's a variety of exceptions to that mechanical application of the exclusionary rule. Inevitable discovery, hot pursuit, so on, right? One of them is the evidence that we're talking about here is sufficiently attenuated, okay? And that, as I described last time, I think we may be talking about over time, right? Or maybe in circumstance, or the circumstance is far enough removed. Was there enough time that elapsed, either or maybe a combination of those two things, that elapsed between the time that the police got the evidence, quote unquote, illegally, and the evidence that is being introduced in court in an effort to obtain the conviction. And the Supreme Court is saying that if it is sufficiently attenuated, and again, there's that phrase, I just took that from the Supreme Court's, from the opinions, from the opinion of the court where the court developed this doctrine, the confession or other evidence has, quote, become so attenuated as to dissipate the taint. We wish that this evidence had been come by legal means, but it's tainted. There's something wrong with it. It's tainted. But is it sufficiently attenuated? If it is sufficiently attenuated, then okay, it's no big deal to introduce it. Go ahead and introduce it. It's somewhat similar to the inevitable discovery doctrine. It's not quite the same thing, but it's a similar idea, and certainly the effect of both of those is to give the state, the police and prosecutors, I should say, greater ability to introduce evidence at trial that previously would have been automatically excluded. Okay, good. What else? Other questions? Well, we had talked about the right to counsel cases, as I recall last time, right?
Yeah.
Okay. Not sure why we're still.
No, we were running out of time, so you kind of just highlighted the cases.
Yeah, I mean, I think maybe that was probably sufficient what we did. As I recall, I mean, I at least told you what the outcome of the cases were, right? Both Escobedo and Gideon, okay? So Escobedo versus Illinois is really the precedent-setting case that establishes the Sixth Amendment right if the defendant or if the accused says he wants his lawyer, then he gets to see his lawyer, okay? Gideon versus Wainwright is a little bit more narrow question, and that is, does the state have to pay for a defense attorney or provide a defense attorney if the defendant does not have the financial means to do it himself? And the answer to that is yes. That's the bottom line with Gideon. I think what you may be remembering is, I think I shared with you this case, Minnick versus Mississippi. Okay, that's maybe where we left off. And that's just, I think more than anything else, that's just a reaffirmation of the basic principle of Escobedo. Because remember what Mississippi had essentially decided was that their policy was going to be allow the accused person to see their attorney once. After that, they can question them as much as they want while in custody, and they don't have to have the lawyer present. And the Supreme Court said, no, once the accused person says that they want their lawyer, they're entitled to have their lawyer throughout the process at all interrogations, unless, of course, the accused person waives the right to an attorney. Sometimes that happens, right? It's going to go a lot easier on you if you just talk and, forget your attorney. Let's work this out, right? So, okay, sure, I don't need my attorney for this. So they have them sign a document. You can bet now they have them sign a document, right? That I've waived my right to an attorney. Now the questioning can really get going. Because, you've all have seen enough films and television cop programs where when the attorney's in the room, the general advice is, don't answer that. Don't answer that, right? You got Fifth Amendment, don't answer that, right? Okay? Yeah.
I have a question. So when you get arrested and you're being questioned, and you don't have an attorney, but you want one, can they provide you one right then?
Oh, I don't think it's instantaneous, but you can bet it's pretty quick, right? They probably take you down and arraign you. And by the time that you're, the paperwork is done and you're in the cell, then, they're getting you an attorney. Okay, good. Let's move to the self-incrimination issue. The lead case there, of course, is the famous Miranda decision. Now, we've talked about, or at least alluded to, the Miranda decision several times, but let me give you a little background on this case. This case involved a man by the name of Ernesto Miranda, who was arrested in Phoenix, Arizona, the greater Phoenix area, on kidnapping and rape charges. During the course of being interrogated, he confessed. And on the basis of that confession, in fact, it was the only evidence introduced by the prosecution at his trial, he was convicted on the charges, and he was sent to state prison. Okay? He filed a petition for appeal. Okay? He appealed his conviction on the grounds that the police didn't tell him he had a right to remain silent. He had a right not to have an attorney, or to have an attorney present. And the Supreme Court overturned his conviction on those grounds, that the police have an affirmative responsibility to inform a suspect that they have a right under the Fifth Amendment not to incriminate themselves, and they have a right under the Sixth Amendment to have an attorney present during interrogations. So Miranda was released. Now, not that it's terribly important, but some of you may be interested. Miranda spent a good chunk of the rest of his life in and out of prison. By the way, he was retried by the state of Arizona. New evidence was introduced, and he was convicted. So he did. What?
I thought you were going to do double jeopardy, right?
No, it's not double jeopardy. When the Supreme Court, in this case, the Supreme Court overturns a conviction, the state can retry. That doesn't constitute double jeopardy. Okay? So that's what the state of Arizona did. In other words, at this time they did some police work. they didn't just rely on the statements of Ernesto Miranda. They went out and did some investigation, right? And whatever evidence they introduced apparently was sufficient to convince a jury that he was guilty, and he was sent to prison. He served his prison sentence, or at least the portion of his prison sentence before he was paroled. He then spent a good chunk, as I started to say, a good chunk of the rest of his life in and out of jail and out of prison, convicted of a variety of things. Ultimately, he was knifed to death in a bar fight in Phoenix, Arizona. And the story is kind of interesting if you can believe the accounts, which I don't have any reason to doubt, is that when the police arrived at the scene where he had been murdered, they found pinned to his clothing a Miranda warning card. That's how Ernesto made his living outside of prison. He somehow obtained a copy or a supply of these Miranda warning cards, and he would autograph them for people and sell them for a few bucks or whatever. You know, in those days, the police, I guess, needed little cards, right? When they took somebody into custody, they would, okay, well, I don't have this memorized yet. So you have a right to remain silent, you have a right to have a president. So he would autograph those things and sell them to people. When the police arrived, there was one pinned to his clothing, which raised lots of questions, but no, they never found, by the way, his murderer. At any rate, that issue aside, the real significance of this case is that it establishes that what we're now all accustomed to, that practice that law enforcement must engage in when they take a suspect into custody, of informing them of their rights under the Fifth and Sixth Amendments. Okay? Questions about that? There has been some debate over when the requirement to administer Miranda kicks in. For many years, there was this debate about when the police are required to read the suspect his rights. Police departments, I think, in their training manuals typically indicated that, well, when they place the suspect under arrest. Defense attorneys, on the other hand, were more likely to argue that, well, even a not so brilliant police officer can figure out to ask as many questions as they want before they place the suspect under arrest, right? Because then you don't have to worry about Miranda. So there's been all kinds of debate about that, but I think the case law would suggest that the court's view is that when the police take the suspect into custody, right?
Here's the thing, so before they arrest you, they can ask you as many questions as they want, right?
I don't, look, I'm not a lawyer, okay?
Yeah.
Number one. Number two, I don't even know if lawyers know. People who practice criminal defense law, or people who are prosecutors, or maybe even judges, I'm not sure that there's 100% unanimous agreement among them when the police have to or should have to administer Miranda. All I'm saying is that it appears to me that the case law best supports the idea that they're required to administer Miranda once they take the suspect into custody.
Okay.
But that doesn't stop somebody who believes that he or she is under suspicion from invoking their Fifth Amendment right before that. For example, they come to someone's apartment, they don't place that person immediately under arrest, they start asking a bunch of questions. There's nothing stopping that person from saying, oh, you know what, I think I'll just keep
I see that in a lot of movies too. The police will talk to them for a little bit, and they won't arrest them, they'll just leave after they get off the questions, and then they'll come back later and then arrest them or even Miranda right.
Yeah, I mean, it has been, and I suspect, that's why people make films like that, because it has been some point of debate or discussion when that is required. Okay, good. Anything else? Pretty straightforward, Miranda. Now, of course, there's some stuff subsequent to the Miranda that I'm going to share with you. So let me start here with the Dickerson case. This case actually has its origins back in the late 1960s. Not the case itself, but at least the legal underpinnings of the case, because in 1968, Congress passed legislation, the United States Congress passed legislation in response to the Supreme Court's decision in Miranda. Right? Miranda was 1966, so just a couple of years later, the United States Congress is passing a law that says that only coerced confessions can be suppressed if Miranda is not administered. In other words, it's an attempt on the part of Congress to pare back on the scope of the Supreme Court's decision. Okay? The case itself originates in the late 1990s. Thomas Dickerson was indicted for bank robbery, which is a federal crime, right? Before his trial in 1999, Dickerson had asked a U.S. District Court judge to suppress a statement he had made voluntarily to FBI agents on the grounds that he had not first received Miranda warnings. The district court granted the motion. In other words, the trial court granted the suppression motion, right? But the Court of Appeals reversed, ruling that under the 1968 law, Dickerson's statements could be admitted as evidence. Why? Because they weren't coerced. And Congress has. Well, I mean, again, it's one of those things that it's not maybe completely clear what that means. I mean, one would assume that physical beatings would constitute coercion. I'm not going to stop beating you until you say you did it, right? That would clearly be coercion, right? But maybe just psychological duress, right? That might also constitute a coercion. So I think a judgment would have to be made by a judge whether or not the statements were coerced. Or maybe some sort of veiled threats or, I don't know what would fall under the heading of coercion. I don't think it just has to be a physical beating, right? Or, maybe restraining keeping somebody in restraints for an extended, or denying them water or something, or that might be considered coercion. Okay, so the district court did grant that motion, but the Court of Appeals reversed, ruling that under the 1968 law, Dickerson's statements could be admitted as evidence. Now, this case was watched by lots of legal scholars, people in the legal community, academics, but also by the general public, because there was a very palpable sense of anticipation that when this case went to the Supreme Court on appeal, that the court might use it as an opportunity to reverse Miranda versus Arizona altogether. Why? Well, for one reason, there was a conservative majority on the court, but more importantly, the Chief Justice of the United States at that time was a man by the name of William Rehnquist. And William Rehnquist had written extensively as a legal scholar in criticism of the court's decision of Miranda versus Arizona. He was a well-known critic of Miranda versus Arizona. And so lots and lots of people go, oh, you know what, the court's going to take this as an opportunity to overturn Miranda. But in point of fact, they didn't do that. And even more surprisingly, they reversed the appellate court decision, saying that the evidence should have been suppressed on the grounds that the Congress of the United States cannot change a decision of the Supreme Court by ordinary legislative act. It's really, for them, a separation of powers issue. Okay. In other words, when the court handed down its decision, Miranda versus Arizona, they were saying, like it or not, they were saying this is what the Constitution requires. And the Congress of the United States can't change that by an ordinary legislative act. Could Congress introduce an amendment to the Constitution that had the effect of reversing Miranda versus Arizona? Sure. But it would have to be by an extraordinary 2/3 majority in the Congress, and then it would have to be by 3/4 of the states. So not likely to happen. But they didn't go through that process. They just passed a simple legislative act, and that constituted, in the Supreme Court's view, in this case in 2000, a violation of the separation of powers doctrine. Okay, so that's kind of interesting to see how these kind of cases take interesting turns sometimes. Okay, next, we already talked about Minnick versus Mississippi, so we don't have to deal with that one again. And in the previous class meeting, we alluded to this case, Arizona versus Fulamonte. I talked about it in connection with the discussion of the inevitable discovery doctrine. What I didn't tell you about this case is that it didn't involve physical evidence that was at question. Should physical evidence be suppressed? It was statements made by the defendant, okay? But even more importantly, they were coerced. They were deemed to be coerced. It was a coerced confession. And the Supreme Court held in how do you say it? Fulminante, right? The Fulminante case, that even coerced confessions do not necessarily have to be suppressed at trial.
Oh, come on.
If the government can prove that it would have found inevitably discovered evidence that would have led to a conviction by other means.
So basically you're saying that as long as it leads to a conviction, they can coerce, they can successfully lead to the conviction, or what is it when they admit that they're guilty? Their confession. If they can confess, they can coerce people.
You mean before the trial or after the trial?
Before the trial, to get them to confess.
Look, I'm not sure exactly what the best way to answer your question is. So let me try this. As a practical matter, I'm not sure how this would work. Okay, so the state's putting somebody on trial. Arizona's putting somebody on trial, and they have this coerced confession, and they want to introduce it at trial. And you can bet the defense attorney is going to say, motion to suppress, Your Honor, before the jury ever gets a whiff of this, right? And then the judge is going to have to decide whether or not to exclude that evidence. After this Fulminante decision, before the Fulminante decision, I should say, there's no question that a trial judge would have suppressed that confession.
Right.
Now there's a question. The question is, can the prosecutor demonstrate to the satisfaction of the trial judge that they would have inevitably discovered this other evidence that was sufficient to lead trial? Now, as I started to say, as a practical matter, I don't know how that would happen. Would they at trial? This is a good question for somebody in the legal community, right, who has the practice of law, either as a defense attorney or a prosecutor or a judge or something. How would that happen? I don't know. I've wondered about this myself. For example, would the prosecutor have to put on all that other evidence first, right, and then say, oh, by the way, the defendant confessed? Or can they, sort of lead with the coerced confession, which presumably would make the jury more prone to accept the other evidence as inevitable? I don't know, as a practical matter, how that works. All I can really tell you is that the court says, just because it's coerced confession does not, most of the time it's going to be excluded, but not under this one narrow circumstance or possibility where the prosecution can demonstrate to the satisfaction of the judge that they would have gotten to a guilty verdict by other means.
What about the police officers, the detectives that coerce the person, like God knows what? Can they be put on trial as well, or are they just left?
Now you're talking about a whole different matter.
Oh, yeah.
There might be federal civil rights violations that they could be put on trial for, sure.
For first people, we gotta figure out how.
You're asking what I think is a very important question, because you have no doubt remember that in the panel discussion program that we watched, there were several participants, including former Supreme Court Justice Potter Stewart, who were making the argument that the exclusionary rule is the only feasible way to prevent the police from flouting the provisions of the Fourth and Fifth Amendments. So others might respond, no, there are other ways to prevent the police from doing that. We could enact laws that would hold the police criminally, and a police officer criminally and civilly liable for violating someone's civil rights. Because if they don't observe their right to remain silent, if they force them to confess or somehow interrogate, then they violated their civil rights. So can we not prosecute police for violating, separate from let the conviction stand, right? They say, right? I'm not sure that's a satisfactory answer. I'm just saying that that's part of the
We
debate.
don't do separate for the police?
Oh, you bet. If you can bet, right? You know, we just had the George Floyd verdict. Okay. You can bet that, you know, there were other police officers on the scene, right? Whether they'll be prosecuted or not, we'll see. I think there are some charges. We'll see what happens with that. But the FBI has already opened an investigation to civil rights violations.
Yeah.
So we'll see what comes out of federal civil rights charges.
Wow.
Okay, you know what? There's so much case law here. Let's just skip over the Howes case. Or do you want to hear about Howes? You want to hear about it?
You can read about it.
Oh, okay, you can read about it. I'll just briefly tell you, it involved the question of whether the police can interrogate somebody who's already in prison for something else without advising them of their rights. Okay?
Wow.
And the quick answer is the Supreme Court says, yeah, they can.
What?
I mean, I guess they do already know.
I
What?
think they really do.
I don't know, that sounds weird. It's like, yes, they've probably already been told them that they're in jail, but at the same time, they are being taken into custody against.
Well, what we're talking about here in this particular case was a situation where the person who was already in prison was taken to a room where they can have visitors, right? And the detectives are saying, well, sure, have a casual conversation about an unrelated matter for what you're, not related to what you're in prison on.
That's coercion, though.
What?
That's coercion. Coercion. Oh, you want to say.
Well, I guess the court didn't view it that way,
Oh,
because the
God.
court said that he could have got up, essentially said he could have gotten up and walked out anytime he wanted to. He wasn't in custody.
That's not how that
He
works.
might have been in custody of the Board of Corrections, but he wasn't in custody of those police officers.
Yeah, but he's in prison.
He wasn't coerced, though. He's answering unwilling.
Well, but remember, it's not just, let's not focus on, I know we had the discussion just now on coerced confessions, but it's not just a matter of coerced confessions. Presumably, Miranda applies anytime the police take somebody into custody, whether they engage in coercion or not.
But
He still has rights right in
was
prison.
he
Yes,
in custody? Because he could have left at any time. So.
in the court's view, he was not in the custody of the police who were interrogating him. He was in the custody of the Department of Corrections, to be sure.
There's a lot of little loopholes.
I think it just depends on whether
Well,
you
that's-
know, whether you know the law or not.
What?
I think it depends on an individual, whether you know what your rights are or not. If you don't know, they're gonna use it against you. But if you know what your rights are.
Oh, you can bet that's true.
If I know my rights, then I'm not going to say
Yeah.
anything. But
Yeah,
if
sure. I mean, the police, I'm sure in that situation are thinking, we're under no obligation to tell him that he can have an attorney present right now, or we're under no obligation to tell him that he's,
Doesn't need a state.
you know, got a right to remain silent.
Worse.
Let's move to the issue of capital punishment. Again, I want to make sure we can get through everything that we really should be getting through here. And I'm only going to share two cases with you here, or two groups of cases, okay? The first one here is Furman versus Georgia, which was decided by the United States Supreme Court in 1972. It was one of three cases that the court dealt with under the same umbrella. It's the lead case. That's not uncommon for the Supreme Court to take up multiple cases dealing with the same issue at the same time. For example, in the famous Brown versus the Board of Education case, you know, that's the case where the court said that segregating white and black school children on the basis of race is unconstitutional. That was just one of 5 cases, I think, that the court was dealing with simultaneously. It's just the lead case. So same thing here. We've got 3 cases, one out of Georgia, or 2 out of Georgia and 1 out of Texas. Okay? And the issues are pretty much the same. Okay? What happened ultimately was that the court decided that the way that the state of Texas and the way that the state of Georgia administered the death penalty was a violation of the 8th Amendment provision against cruel and unusual punishments and a violation of the Equal Protection Clause of the 14th Amendment. That's the provision of the Constitution that prevents the states from treating people differently on the basis of race, creed, color, previous condition of servitude, etc. Yes.
So what form of death penalty were they carrying out that caused them to say it was unconstitutional? Because there are some that they're okay with, but I guess what was particular about this one?
Well, at the time, this would have been in a period before any states probably, but certainly most states were using lethal injections. They might have been using hangings or firing squads or
So not barbaric.
I would say that hanging was actually.
Or electric chair. Certainly the electric chair, right?
Yeah.
Okay, so, but I don't think it was really so much about that as it was a question about how much discretion juries had in invoking the death penalty.
Oh,
So we can we'll get into that here in just a second, okay? One very little, not little, I shouldn't have used the adjective little, but one specific piece of that, generally how much discretion juries have in invoking the death penalty, but there's a more specific issue here as it relates to race, that there was a lot of evidence by this time that African Americans who were convicted of a crime were much more likely to receive the death penalty than whites who were convicted of a crime. So there was that 14th Amendment issue as well.
it is the same crime?
Yeah, I mean, if we're talking about the same crime, if it's a capital crime under state law, kind of circumstances that would qualify something as a capital crime, if the defendant was black or the convicted person was black, much more likely to get the death penalty than a white person who's white.
Okay, so that's it. The crimes are different, and depending on how the case goes, it would be possible.
Yeah, but hold on to that because I think the kind of question that you're raising is going to become an issue here in just a second. So we'll look at that, okay? So initially here, the issue is just, how the states administer the death penalty. I guess I could say this. I think the problem that the court found in the Georgia cases and in the Texas case and presumably in other states was that their death penalty statutes were too vague, too much discretion, too much, the parameters weren't well defined enough. And so it became a discernible pattern that juries were very, very quick to invoke the death penalty without taking mitigating factors into account, et cetera.
That is,
Okay.
death penalty is done when the person's practically 80 at that point.
All right. So that's Furman versus Georgia. Now, one of the things about this case that's very important for you to understand, seems like ancient history, but at the time, it was widely perceived by the general public that the court had declared the death penalty itself unconstitutional. And I'm here to tell you that the Supreme Court never said at any time, this case or any other case, that the death penalty in and of itself is cruel and unusual punishment. What they said is the way that the states are administering the death penalty is cruel and unusual punishment.
So they're basically
So-
saying death penalty is fine. Just do it.
No, let me sort of finish off this point, okay? So in response to the court's decision in the Furman case, there was a nationwide in all of the states that had the death penalty. There were some states at that time that already didn't have the death penalty, but in states that there was this national moratorium on administering the death penalty. So there was a period of 4 or 5 years there where no states ever executed anyone, okay? After the Furman case, but in the Gregg case, I thought, do I not have it on here? Oh, there it is right there. Yeah, I thought I had it on. Why isn't it clicking? Okay, well, I'm just gonna have to tell you about it. Somehow the link's broken, okay? In 1976, just a few years later, the question was raised again. What happened during that moratorium is that state legislatures in Texas and Georgia and Louisiana and Florida and all these other states that had similar laws to what had been struck down by the court in Furman, the state legislatures went to work and they rewrote their death penalty statutes. And those came under the scrutiny of the court in the Gregg case, which also came out of the state of Georgia, but there was another case that came out of Texas. There was one that came out of North Carolina, went out of Florida, went out of Louisiana, I think. I think there were like 5 different cases. that the court took all under the same umbrella. I think the Texas case was called Jurek versus Texas, if I remember correctly. It's not a big deal, okay? So now what the court is reviewing are these new death penalty statutes. And in all but one of those cases, the Louisiana case was an exception, but in the other cases, the Supreme Court upheld the new death penalty statute. It upheld the death penalty statute, the new death penalty statute of Texas and of Georgia and those other states, okay? So subsequent to that decision, what do you think Texas and Georgia and those other states renewed, or they started doing the death penalty again, okay? And it's not a secret to anyone here that Texas is one of those states that leads the nation, in fact, in executions. Right? So it's been, it's been, yeah, but I don't want to go to that link. Let's hope for some reason this link's not working. Okay, anyway. By the way, I didn't mention this to you. In the Furman case, one of the issues that was raised about, the death penalty statute and how it was applied so readily had to do with the specific circumstances of Furman's case. He had broken into a family's home believing that no one was home, but he was surprised when someone came in on him, flipped the lights on, came in on him. He dropped his gun and it fired and killed the resident of the home. And so the state of Georgia never allowed the defense to prevail on that argument that there were these mitigating circumstances, that there was no intent on the part of Furman to kill anyone.
Right.
And that's the part of it that the court is taking exception to, that the death penalty statutes are too broad. They need to be more parameters need to be more precise. Yeah.
See, that sounds difficult to me, because that sounds like that, if that's true, if that's really what happened, if you're telling the truth, if there weren't any witnesses, that sounds like manslaughter charges, but at the same time, he did have guns, so it's not like he wasn't prepared. Like, why else would you bring a gun to?
Yeah, somebody who's interested in that, maybe go back and look at that. Now that you're asking that question, I'm not sure if it was a gun that he brought with him, or if it was the homeowner's gun. Now, I mean, you've raised an interesting question, and I've just forgotten. It's been long enough now that since I've looked at this case, that I've forgotten what the specifics are.
Because then it sounds like he could have had the intent to murder.
Yeah, now, since you're asking the question, now I'm inclined to think that what I remember is that the jury convicted him on a capital offense because the Georgia death penalty statute allowed for that in the commission of a robbery, even if the firearm was not, or the weapon was not in the possession of the person who was committing the robbery.
That was like a pretty low bar for that.
Look it up for us. I'd be interested. You come back and tell me what the circumstance. It's not that hard. Just go Google. If I can remember, I'll do it too. But go Google Furman versus Georgia and just click on, like, the best link you're going to find is probably the Oyez link. It's OYEZ, and it'll tell you just in a paragraph what the facts of the case were. It won't require you to do a bunch of research. And I hope I'm remembering the part that I've conveyed to you. I'm remembering correctly, because I'm finding now I'm having a hard time remembering the details of that case. But, yep.
Oh, the question about this capital offenses, that last one is kind of weird. Under 6, what is that? Why is it so specific?
Your guess is as good as mine. I mean, I don't know, why did they make it 6, and why didn't they make it 8 or 10 or whatever? But that's just what the legislature decided.
I guess.
And then a lot of these
Too innocent at age 6, right? Like there's.
Yeah, like what's so 7? You're not innocent anymore.
They haven't gotten to live 7 years before.
So like, as soon as you hit your birthday at 7, you're grown now.
Yeah, so let's run through these here real quick. I told you that Texas rewrote its death penalty statute, and there may have been other changes since 1976, but these are the provisions that are currently in place in Texas. Okay, so what constitutes a capital offense in Texas? murdering a police officer or firefighter who is acting in the lawful discharge of an official duty, who the person knows is a police officer or firefighter, committing a murder for pay or promise to pay, or employing another person to commit murder. That's subject to the death penalty.
Assassin.
Committing a murder while escaping or attempting to escape from a penal institution. That's a capital crime. Murdering a prison employee while incarcerated. Committing a gang-related murder while incarcerated. Committing a murder to obstruct justice or in retaliation against a witness in a criminal case. Committing a serial or mass murder, or murdering a child under the age of 5. So any of those potentially could get the death penalty in Texas. It doesn't mean that upon conviction they will get the death penalty. That's the next part we have to talk about.
I would say, I'm curious about what they define as mass murder, because for example, when people say mass shooting is literally defined by like 3 people being shot, not even killed, just shot. So I'm curious.
There may be some specific provisions in Texas law that would define that. I don't know.
And it's weird that they're together, committing serial mass murder and then murdering a child under 6. Wouldn't that fall under the committing serial or mass murder? 'Cause you're killing
Not
someone.
necessarily.
No, serial is multiple people.
Yeah, but still committing a murder, you know?
I thought.
Why just not, if you murder someone, why did it make it, if you murder someone, it should be capital offense?
Well, it depends if it's accidental, that would be manslaughter. Like if you got in a car wreck and accidentally killed someone, that's manslaughter.
I think, look, here's my answer to your question. I think what the state is saying is that there are some acts that result in the death of innocent people that are so heinous that they ought to be considered capital offenses.
So I guess it kind of depends on the judge.
Well, not the judge. This is what the legislature is saying. The legislature is saying you kill a child under 6, doesn't mean you're going to get the death penalty. It means that it's a possible sentence. Okay? All right. So that brings us to the next point, okay? Which, what are the penalties for a capital offense? Well, it's not necessarily the death penalty. There are 2 options in Texas: life imprisonment without the possibility of parole, or the death penalty. So a jury can determine either one of those 2, okay? But to determine which, or a judge, if it's a judge that's handing down the sentence, to determine which, the jury or the judge must answer 3 questions. First, was the conduct of the defendant that caused the death of the victim committed deliberately and with the reasonable expectation that the victim's death would ensue? They're going to have to make that determination based on the facts.
So like they planned it beforehand.
Was there intent? Okay. Is it probable that the defendant would commit additional criminal acts of violence that would constitute a continuing threat to society? If the answer to that question is yes, maybe they invoke the death penalty. If the answer to that question is no, it's going to be life imprisonment without parole. Okay? And then third, is there anything in the circumstances of the offense itself, like tripping and falling and a gun firing, perhaps? Is there anything in the circumstances of the offense and or the defendant's character that would warrant a sentence of life imprisonment rather than the death penalty? That's the portion of when you're at the sentencing hearing and the defense is going to bring in character witnesses, right?
He was a good boy.
Or suffered abuse,
Yeah.
as a child, or who knows what the
Like,
mitigating
yeah, like
circumstances.
if they're mentally ill, then instead of like prison, they go to a mental facility.
Well, what we're talking, okay, maybe, but what we're talking about here is the question of death penalty or life imprisonment. That would be a separate issue, but that certainly would come up at a sentencing hearing. Yeah. Okay, so that's pretty much the status of where we are currently in Texas, and more generally nationally, is that the state legislatures, if they can craft death penalty laws that provide these more well-defined parameters and that provide some options to the jury for life imprisonment as opposed to a death sentence, then the court says that they're okay. Death penalty itself is not cruel and unusual. In fact, the court never, certainly not unusual. I guess the cruelty issue would be up for debate depending on someone's moral persuasion, but that's where the death penalty stands currently. Okay, any questions? Oh, there's that. Now there it is. So there are the cases I was talking about. 5 cases. Greg versus Georgia was the lead case. All right. We don't have a whole lot of time left here, but there are a few things, just kind of little tidbits, little bits of information that I want to sort out with you, because, for example, a couple here that we're going to talk about came up in that video that we watched. Okay, so you may be squared away on these, but just to say that we did it, let's run through these. Okay, so a motion to suppress, again, is the request by the defendant. The prosecuting attorney is never going to ask for a motion to suppress, right? It's going to be something that's going to be asked for by the defense, right? To disallow or exclude physical evidence or statements that incriminate the defendant on the grounds that the police obtained the evidence in violation of the defendant's constitutional rights. Okay? Everybody should have that down by now. Here's one that came up in the video. The change of venue issue. It's the ability of the justice system to remove a trial or send it to another jurisdiction, presumably to promote the selection of an impartial jury. The way they talked about it in that program, you'll recall, was in the context of the media coverage. Okay? Another one that they alluded to in that panel discussion as a way to ensure an impartial jury is to sequester the jury. So this is the idea that in the judgment of the trial judge, if the seated jurors may be influenced by media coverage, the judge may order that the jurors be held in a location where they would be insulated from news reports. Tell them they can't have their smartphones. Tell them they can't browse the internet. Would be a more contemporary application of, I suppose. Nobody reads the newspaper anymore, so that's probably not an issue, right? Or very few people watch television news anymore, so probably can't have your smartphones to surf the internet or browse the internet. Okay, and here's a term that is new to you, at least we haven't encountered it yet, although they alluded to it in the program. Voir dire, from the French, is the oath that's administered to a proposed witness or juror by which he or she is sworn to speak the truth in an examination to ascertain his or her competence. And in that program that we watched, generally as well, it refers to the pretrial jury selection process, so that defense attorneys may be able to disqualify, or prosecutors may be able to disqualify a juror based on how they answer certain questions that they pose, believing or successfully holding that this person can't be an impartial juror. All right, last but not least, we'll end on this. If early, great. If not, just depends on how much you want to talk about these, I suppose. Thought we could spend a little bit of time talking about, since it is the area of law that seems to be the least settled, circumstances under which the exclusionary rule might apply, or more generally, the requirement to get a search warrant may apply. Okay, so I've just got several bullet points here. I'll just run through them and tell me what you think. Okay. Did the police have to get a search warrant to surveil the backyard, let's say, of a person that they suspect to be engaged in criminal activity?
Part of the house.
I would say,
Yes.
It's a part of the house.
I'll say yes.
it's
And
part
take,
of the property.
and let me just take photographs.
Yeah,
It's
that's
still,
still definitely,
it's
yeah,
still the
absolutely.
property.
Part of the house.
Everybody agree?
Yeah.
Well, the Supreme Court demurred. The Supreme Court says no. They don't have to get a search warrant.
Okay, let me ask you this, if some random person
Well, it's your
would
backyard.
just is able to stand in your outside of your backyard, just stand there and just take pictures?
You know,
That's,
Like
isn't that,
legally?
Yeah, that's
Does
not
Google
legal.
have anything to do with?
Well, I suppose if they come onto your property, they're trespassing. But if they stand on the other side of the fence on a ladder and take pictures of stuff in your backyard,
Is that an invasion? of
they're
privacy?
free to do that.
I mean, when you think about it.
How can it be an invasion of privacy if you're not keeping whatever it is you're trying to keep from them private?
Well, I mean, you're still in your backyard.
It's still on my property.
They're putting their arms over. to take pictures.
Okay, I don't know about your particular circumstance, but this actually stemmed from a real case that came out of the state of California,
Oh,
in which
God.
the police flew an airplane over a suspect's property, fenced property, and took photographs of marijuana plants,
Oh, that's-
that were growing.
that's very
okay?
not right.
And he argued that they should have gotten a warrant. And the Supreme Court said there's no presumption of privacy there. Short of putting a dome over the top of your yard.
What?
If
Look,
I built a fence-
Let me go back to the issue that I told you about in the previous class meeting. If you have a big, what do they call the big, the big glass windows at home? What is it called? You know, those big, wall of windows, right? And you stand butt naked in front of your window where your neighbors can see, and the police come and arrest you or cite you for an indecent act or public lewdness or whatever. You say, oh, it was in my home, it's private. Is that going to prevail? No, because there's no presumption of privacy. If you had any presumption of privacy, you would have pulled the shades, right? So if this guy had what the court is saying, I'm not telling you I agree with it, I'm just trying to help you understand the court's logic. The court's saying if he had wanted privacy, he would have put up some sort of, canopy over his backyard so that people flying over can see. Look, believe it or not, this is a pretty big deal for the court. This is a pretty big deal for the court. If an average person flying over an airplane could look down and see, and there's no presumption of privacy, then there's no, or look down and see what's in the backyard, then there's no presumption of privacy. Right?
I think that's.
So anybody can fly over your backyard.
Yes.
Cool.
So what am I supposed to do? Set up a missile defense system for my backyard?
Well, you don't think that aircraft are going to change their flight plans to avoid flying over your backyard, are you?
Airplanes, their intent isn't to get something from you. They're just flying.
That's not the point. Is the point that the court says is relevant is that any general person, police officer notwithstanding, could fly over that backyard and look down and see what they had growing in their backyard. Therefore, it wasn't a search by the police that was subject to the search warrant requirement, because there's just no presumption of privacy.
I would say one thing about it is, I mean, like Google, for example, they have satellites. You can look at Google, or you can look at your backyard any time. I mean, they take pictures of everyone's yards.
Sure.
I mean, that's another thing. Like, they don't need a
You're
warrant.
gonna stop Google?
I think it's.
Only way you stop Google is putting up something over your backyard, right? How about this one? How about thermal imaging? The police, those FLIR guns that police have?
No what?
They come to your home with a FLIR, F-L-I-R. I forgot what that stands for. Infrared camera. Right? In other words, it can see heat. Like, you've seen the images, right? Kind of see the outline of a person because their, body temperature is hotter than the space around them or whatever. So can the police search that? Maybe they're looking for, say, equipment that might be used in farming marijuana plants inside a home.
I love how detailed they are trying to convince.
So to use the thermal imaging, do they have to go inside my house, or would
No,
they be able to
from
do it
outside, probably from across the street.
Man, that's great.
Look, that's what happened in this case. The police went and surveilled a suspect's property, believing that the suspect was engaged in drug trafficking, engaged in growing marijuana plants, and using heat lamps and so on. And they pointed the infrared gun in that direction, and they saw what they argued was evidence of heat plant growing equipment. And on that basis, established probable cause and went and got a search warrant. But the defendant argued that they should have had a search warrant to use the thermal imaging in the first place. What does the court say about that? Do they need a search warrant?
Nope.
Yes, they do.
Oh, wow.
Well, because I would think thermal imaging, it's not gonna be as exact as you would hope, so you don't know if it, even if you do pick up something, you don't know if it'll be good enough.
Yeah, because what if he just grows flowers and?
Yeah, but do they need
Yeah.
do they need the search warrant to conduct that kind of surveillance in the first place?
No,
Is
they need
the
to
question.
make this up.
And the court says they have to have a search warrant.
This is so-
Okay? How about if the police come to the person's property, let's say it's their residence, and based on their sense of smell, they've got, marijuana in there, and they bust in before they have a chance to dispose of it or whatever, and place the suspects under arrest and take the evidence into custody.
I don't know about that one.
Would you need fall under hot pursuit?
But,
I think they don't need a whole.
yeah, the Supreme Court says they don't need
They don't
a
need
search
it.
warrant. If we're talking about the officer's smell. But if they bring dogs with them, okay,
Well, yeah.
and the dogs are trained to sniff these things out, they say that constitutes a search that you need a search warrant for.
Is it because of the accuracy?
It's because anyone can walk up to your house, any person can walk up to your house and smell that smell, okay?
Oh,
Only the police bring search dogs with them.
I mean,
And if that sounds like a fine point to you, or kind of that's just, remember, it's a matter of line drawing, right? Where is the court
I
going to
guess.
draw the line?
I mean, I guess they would say, if any person from the street could smell it from your house, then there was no assumption of privacy.
Basically, what I'm learning now is, for a short brief time, the courts were getting their butts kicked by convictions and stuff, a lot of people let it go. So then they decided the next 20 years, from then on, this isn't happening. We're gonna be as strict as we can, we're gonna get to the fine points as quick as we can.
Oh, I don't know if I'm that cynical.
They're really
I don't know if I'm
detailed.
as cynical as you are. I don't know if it's so much what they perceive that they're getting their butts kicked. It may just be out of a concern they have for society. You know?
I mean,
Violate your right.
it might be less.
Let me finish this up here real quick, okay?
Okay.
Because we're almost out of time. How about GPS tracking devices? They got to get a search warrant for that? Yes, they have to get a
Yes,
search
absolutely.
warrant.
That's
Okay, okay.
dangerous.
How about to get cell phone data and text messages? They do, that's right. Do you all remember the case just a few years ago where the FBI was trying to get data from Apple and Apple refused?
Yeah.
And they- right?
It took away their.
The courts have said that data belongs to the companies. Doesn't belong to you, it belongs to the companies. But if the companies, I don't know if you knew that, right? Your data in your device, that's not your data, that's the cell phone company's data, but, which is why they can sell it and all that kind of stuff. But at least when it comes to the government, they have to get a warrant. They have to show probable cause. They can't just, take the data, say, give us the data, right? Okay, and then last one I have on here, boy, there's certainly lots of other questions, but ran out of space, so just one more. How about drone surveillance?
Well, that sounds oddly close to aerial.
I think we don't need.
Yeah, it may be closely related.
I mean, I guess anyone could fly a drone,
Yeah.
technically with a camera. I mean, you can buy those.
Well, are you
can
talking
buy
about going
mini ones.
inside the house with the?
I think it depends on the space that's being searched, right?
Yeah, like, it's just.
But really, the reason I put this one on the list is because, at least when I compiled the list, the technology is still pretty new, and I think there's a lot of questions to be settled about it. Certainly, lots of police departments, sheriff's departments, and so on have purchased drones. Don't the authors of your textbook tell you the story about the sheriff's department here in Texas that bought a really expensive drone and, like, on its first flight it crashed? And but lots of police departments have that technology now, and I think it's just a question of what they search with it. I put it on the list here because I really think it's a good place to end, but also because I think it illustrates that the law really does have a tough time keeping pace with advances in technology. That's one of the real problems that we face in this particular area of law, is that the changes in the law, legal process just doesn't move as fast as the technological innovations. All right. You have any questions, comments? Okay, well, we can call it end of this topic then at that point. Dismiss a few minutes early today. Next week, we're gonna come back and deal with my favorite, topic of the semester, and that's taxes.
Taxes,
Ooh,
yes.
Death and taxes, only after this.
Okay, we'll see you on Tuesday.